Hello, everyone. Welcome to our session on European legal challenges for tech businesses. This is ideally interactive, so if you're very welcome to join in, ask your questions, whatever you may have. So otherwise, I will report a little bit on our experience. First of all, maybe let's have a look at what I would like to look into here. From the start, I'd give a little introduction, who I am, who my firm is, and then my proposal is we jump into a couple of examples of our advisory practice, which we look into, which is really fairly broad in terms of tech issues and tech projects. And then I'd like to give a couple of remarks on one of the topics which has turned out over the last couple of years to be pretty crucial for every business, but of course, in particular for tech businesses, which is the GDPR, General Data Protection Regulation. So, it's not entirely new anymore. It came into force in 2018, but still has quite a lot of significance. And then let's take it for a Q&A. But also, please always feel free to jump in. This is really for you guys to benefit from that, from a little bit of my legal experience here. First of all, a little bit about our firm and myself. I'm Thorsten Kraul. I'm the co-head of the digital business practice at NER. NER is a German-based European law firm, a full business firm. So we are basically handling everything that legal that a company needs, from setting up a company, the entire corporate work, transactions, and also we are pretty active in the Berlin tech environment, having founded essentially, or at least advised on the foundation of a couple of unicorns that came out of the Berlin space from start until sometimes IPOs or M&A transactions. But the other part is, which is very important for us, is understanding the needs of the businesses as they develop and as they grow. And this is essentially what I do a lot for tech business of various sizes, small ones, bigger ones. We have quite a couple of corporate investors coming to Berlin these days and setting up shop. And so this involves, it's quite an exciting work. We're working with the founders, working with the investors, getting to know the environments of their technology, and over the various projects that we've handled, we've gained quite a bit of experience on a couple of technologies and topics. And what my idea is, I'd like to share our thoughts on a couple of these today. We've advised, obviously, on a couple more. One of the most important business, which I intend to go into in a little more detail, is the platform like Amazon or Uber or Facebook or the likes, the big ones, but obviously there are a lot of smaller ones that are growing, or and an important business model which we've done a lot of work on is the Internet of Things, and I'd like to give you a bit of perspective on that. Also, obviously we've worked with big data analytics, then the IT foundation of everything, the cloud business models, which are pretty established right now. All this in various sectors, from banking to automotive, retail, farming, healthcare. Very, very interesting and important sector, energy. And sometimes they are regulated, so we have our regulatory experts coming into this, of course, along with our my group of people. So my proposal is we jump right into a couple of those technologies here, and I'd like to give the platform a start. Right now, I'm advising a couple of platform businesses on their needs, on their setup, and what that starts with is obviously it's an IT project first of all, but then the platform being probably the most successful business model in the internet world. Who would have thought a couple of years ago businesses like Uber coming along without owning cars being immensely successful, or Airbnb, a platform business without any flats, but renting out, or serving as a platform for landlords to rent out their businesses. So from a legal point of view, alongside general requirements with regard to the IP that the company needs, of course, domains, trademarks, software development. A very crucial part is what actually happens on the platform. And one of the most important issues for a platform is how can the platform shield itself essentially from the potential liability for what goes on the platform. And there's quite a lot of legal background to this and significance to this. First of all, there's European legislation on it. There's the so-called e-commerce directive, which says if you're acting as a platform and you're merely passive and people on the platform put up content or conduct their sales or whatever they might do, as long as you are just passive in nature, you are for a start not responsible for what happens on your platform. But this comes with a couple of reservations. First of all, there's ongoing discussion in the European Union and even legislation right now to start holding companies like Facebook, Twitter, and the likes accountable for illegal content, or to force platforms such as YouTube to actually acquire rights in the content that's on there. So that's a push for it, but the general rule is you can still and should, as a platform business, seek to shield yourself from liability on the platform by applying a couple of standards, which is essentially you don't control the content, you don't really organize it that much, you don't take exclusive rights in the content that's on there. You always make it clear it's not yourself who's acting, putting up the content, and so on. And that's an important thing to put in your contracts. Also, with your, well, on the one hand, if you're looking at platforms such as Uber or the Amazon Marketplace, with your vendors, it must be very clear they are just using the platform. You don't take responsibility for what they are doing there. They take responsibility, and on the other hand, make it very clear in the user terms and conditions as well. It isn't always easy to achieve that, but at least what we're advising our clients to do is get as much as possible into the direction of just a passive nature to at least create an argument as good as possible so they are a platform. So this is, in a nutshell, I would say, most crucial legal topics about platform. What I would also like to discuss with you and give an overview on is what's the legal framework for the Internet of Things. It's obviously a great technology. How does it work? There's a device, a so-called smart device that's collecting data, and that could be a smartwatch, or it could be a machine, or there could be a sensor in the turbine of an aeroplane that's collecting data, and then what happens next from the device over the internet, those data are transferred to the cloud, to a platform where they are stored, and they are then analyzed, used, or just kept for future analysis or use. And then an example of application could be if you're looking at maybe a healthcare application. It could, if you have a wristband, and if the pulse indicates that a person might be close to having a heart attack, it might automatically call for a doctor and get help. So, and there are a lot of very, very interesting applications to this. So if you look at the legal framework, obviously depending on the industry you're in, there is some regulation in it for it. If you're looking at healthcare, it might be considered a medical device, and there's new European regulation on it. It might be the question whether on national codes, and we've had that discussion in Germany. It's not that advanced in those digital technologies in healthcare that until very recently it wasn't permitted to actually connect you to a doctor online and give medical advice. So there might be that regulatory issue. But one of the most key points about the Internet of Things, basically that we are confronted with all the time is that if you're looking at IoT from the perspective of a service provider who's bringing in the platform, and on the other hand, there are customers with smart devices transferring data onto the platform. The key issue is that you as a provider don't control what's happening outside of the platform. So you're not in control whether user data are right. And there's that well-known principle, so-called garbage in, garbage out. So on the platform, the analysis the platform can produce is very much dependent on the quality of the data that come in from the users, which are not controlled by the platform. So in drafting terms for such a service, it is really crucial to take account of that, to just, the promise can only depend on, well, there's an analysis on the basis of the data as they come in. That's a typical rule that we draft into those contracts. And another point is where the platform doesn't control what's going on is whether the data that come in are actually owned by this customer. So and then we are coming back to what we discussed before on the platform, because some risk mitigation can be taken by the right platform design. In particular, designing it as a passive platform, which is just storing the data, so that the platform operator is largely shielded from claims. The way that works usually when there's illegal content on a platform is that a third party comes along and claim, oh, hang on, this is my data, or this is my IP, or whatever you're using. So take it down. And as long as the platform operator has processes in place to actually react fairly quickly and to remove those data or illegal content quickly from the platform, there's no liability. But if those measures are not in place, the operator can become liable. So there's a certain aspect of shielding in it, which should also be applied to an IoT platform. Next step is essentially there's this, in order for the data to come along to the platform, be actually able to be analyzed and stored there. there's an active transmission of the internet, and obviously this is something that the provider of the platform has no influence on. So usually there's a clause in user terms for IoT services that the service provider takes no responsibility for a correct, complete, and timely data transfer on the platform. Then in the next step, there's oftentimes an analysis of data going on the IoT platform, and oftentimes it's not really predictable for the operator what's the purpose of the processing and what's coming out of that. And this is in particular, and there might also be something wrong because data are incomplete or something like that. The algorithm doesn't work as it should. And this is depending on the sort of application that the platform works might turn out to be pretty dangerous. If you think about medical applications where, for example, based on certain data, insulin is injected or something like that. If the analysis is wrong, the result might go terribly wrong. So what we typically do is that we include responsibility of the platform operator for the results and the usability of the outcomes of the analysis. So this is pretty important. Then there's other points, which is who's actually the owner of those data? Is it the person that's bringing the data on the platform? And also, as a platform operator, you might be interested in learning from the data that are coming on the platform. So there's usually a rights clause in those agreements. All right, so those are a couple of things. Obviously, we could talk about IoT quite a bit more, and there's a book. I'm the editor on a book of a book on IoT, which is coming out right now, and it has around 1,000 pages. So it's a pretty big topic, but this is a small overview. I'd like to touch briefly on another very interesting topic, which is robotics and AI, and some of the legal applications and implications of it. What's really interesting about it, and the main challenge from the legal point of view, is that the results of what's coming out of AI is not really predictable. Because the way it works usually is it's an algorithm and it's fed with data and then it's self-learning. And so you cannot really say, for example, if you have an algorithm which determines certain best routes through a city, you cannot really predict how the algorithm is going to develop and then which direction is actually coming out of that. And that is pretty challenging from a legal point of view. Think of liability, for example. So you cannot really, there's always an element of uncertainty and risk in it of using AI because you don't know exactly what the result is. So in order to avoid liability exposure, what should be done once is giving it a framework of what the AI is actually able to do. That is immensely helpful from a risk mitigation perspective. But also looking at what the law says about liability, it is actually fairly friendly to those, at least in Germany, fairly friendly to those services, as it in IT systems acknowledges the inability of a provider for full control, stating essentially that it's sufficient if the systems operated properly and maintained properly. But of course, if you go into the contracting sphere, it should be reflected in your contract, first of all, that with your customers, if it's AI based, that there is that uncertainty in outcome. So it shouldn't be a commitment to a certain outcome, but rather to a functioning algorithm on its basis with an element of risk for the user in it. And another important point again here is the IP side and the data ownership side, because what happens when you have an algorithm use customer data and learn from it is that there's an output data. So there's a question who's the owner of that, and then there's also a further automatic development of the algorithm itself. And as a provider for your service to grow, your business to grow, it's pretty important to keep the rights in it with you. Okay, so this is also a very, very short overview on a couple of legal implications of artificial intelligence. We only have a few minutes left, so what I would like to share with you is a couple of thoughts on the General Data Protection Regulation. So what is it? It's essentially a Europe-wide law on how processing of personal data is regulated. It's come into force in 2018, and it's not like there hasn't been any data protection laws in Europe before. So there was even a European directive regulating that, but it came with a couple of additional documentation requirements. So every company, essentially every company nowadays needs a register of their processing activities. So what are they doing with which personal data? And also there's a much harder set of fines if a company doesn't comply, and there have been fines in the amounts of millions by now. So it's pretty serious stuff. So it goes up until 4% of group turnover of a company. And if you think of a big company, a big industrial company, or a tech company like Amazon or Facebook, that's quite substantial. So if you look at that from the perspective of maybe an Israeli company, you might ask, how am I concerned with that? Well, if you'd like to serve European customers and using personal data from them, unfortunately you are, because now under the GDPR, it's really quite clear, it's absolutely clear that then regardless of whether you have an establishment within the European Union, GDPR applies to you as long as you deal with European data. That hasn't always been so clear, but now it has led to essentially all international companies adapting, who do business in the EU, adapting their internal policies and procedures to the GDPR. What's the main principle? The main principle is under the GDPR, a company is not allowed to process personal data in any way unless it's permitted. And there's one which is normally preferable. There's a set of regulations that say under these circumstances it's permitted to use personal data. The most important usually being it's necessary to serve a customer contract. So if you're providing, say, a data analytics service for your customer, you can also use the customer data for it. But anything that extends that use that's necessary for the contract needs a different justification. That would oftentimes be a consent, which is a declaration of the customer, okay, I'm okay, I agree with that data processing, but there's a couple of requirements for it, and usually there needs to be an explanation what's being done, and there needs to be a clear consent on that. Then, last but not least, let's look into data transfers out of the EU. If you're an Israeli company, you're lucky in that because the European Union says, well, Israel has data protection standards that are sufficient from our perspective. The data can be transferred freely between the EU and Israel. But it is very different, for example, with the US. And as a basis, there's been an international agreement between the EU and the US that formed the basis for that. That's the agreement on privacy shield there. And the European Court of Justice just recently, last year, held that this agreement is void. And so there's that's probably the biggest issue of data protection right now. So there's immense discussions on how to solve that right now. And usually the way that businesses take is they enter into special arrangements which prescribe additional requirements for the safe handling of data. One part of it being possibly encryption. All right, so I think we're at the end of our timing. Let me say thanks to everyone for your attention. I'd be very happy to be in touch with you. Feel free to contact me if you have any remarks, interest in any of those topics. So I'm looking forward to hearing from you. Hope you enjoy the rest of the conference. Thank you and have a good day.